us right now, so that's wonderful. So hi, everybody. This is Jennifer Fox with Fox Property Management. I'm so glad you got on the call with us today. I'm really excited to have Pete Muccio on the call. He is one of our attorneys and just a great resource. We rely on them quite a bit to do excellent work for you. We definitely use expertise where we need to use expertise, and not being, if we need expertise in insurance, we talk with insurance experts. And in this case, with all the new laws that have come out in 2025 that are all being activated into 2026, we really wanted to bring Pete on to go through each of the different legislative items that have been voted in and passed, so that you can have an idea. Some are going to impact you differently than others, and so Pete will go through each item. We'll have them on a slide, and we'll be recording this. So I'm going to make sure that that's happening. So we'll be recording this, and we'll share it with you later as well. So Pete, I think you can get us started, Hannah. So we're going to start with introductions, and then we're going to review the 11 different laws that have passed, and then we'll do Q&A at the end. Most likely what we'll do is at the end, we'll ask for questions, and Pete will go ahead and give you answers as he can. And our plan is to do all of this within 1 hour. So our goal is to review everything for the first half an hour and then leave time for questions at the end. So Peter, if you want to introduce yourself, that'd be great.
Sure. Thanks, Jen. Thanks for the opportunity to be on with you here and to talk about the new laws. As you summarized, there's an awful lot to talk about. And, with 11 different laws, we're not going to take a deep dive on each bill. We'll just kind of take the high level, make sure that there's some awareness of what some of those issues are. And about myself, I've been practicing law since 2002, and have been practicing with the firm since 2003. And the firm's gone through a few names changes over the years, but my preference is I really like the current name that we are right now, which is Cheddar Sulzer Muccio. So call me biased, but I don't know, it's got a nice ring to it. So, but yeah, I think there's a lot to cover, so I guess we might as well just kind of dive right in, right?
Great.
All right, so this first bill, HB 25-1053, is really, just something to be aware of, right? There's not a huge operational shift here. What this bill does is it allows for property managers, it allows for landlords to have some comfort when you're dealing with allowing police access or any emergency personnel access to a property, right? And so it provides you with some immunity from civil damages related to injuries when you're allowing access to the property. This is a really big deal. I was at a conference earlier this year with attorneys from around the country, and in some jurisdictions, people say don't allow access, right? They'll say, hey, if the police want to knock the door down, let them knock the door down, because you don't want to get into a liability situation. This is one of those areas that actually provides some comfort and some benefit to landlords. And I love that this is the first slide, because this is probably one of the more landlord-friendly changes to this past legislative session. But as far as a new change operationally, there's not a big lift here. It's just something to be aware of, that there are some protections so that if you are allowing access to emergency personnel, you're not signing up for a big lawsuit at that point. At least
Great.
Not related to that issue.
Yeah, that's great. Thank you.
Yeah. So prohibitions related to rental agreements due to death. This one, again, not a huge change that's going to happen, but basically, the real shift here is that, when somebody dies, that's not a lease break event that's going to be terminating the lease in the sense of, hey, there's going to be some damages. Yes, there is a termination of the lease, but there's also, kind of a clear, hey, look, we're done here in a sense. And there's also this alternative method of getting possession of the property if you have a situation where the property's been abandoned and the rent's been unpaid, and you have a personal representative who is communicating that, hey, look, we're no longer in control of this property. Again, not a big change here as far as from the operational standpoint. This actually meshes a lot with some of the advice that's been given to property managers in the past in dealing with tenant deaths. Part of the reason for the background on this bill was there was a situation where there was a property that the next of kin received a notice related to a collection matter, and that sort of set the ball in motion to have a legislative fix to make sure that that's cleared up again. Now, you can't have a situation where there could be a death at a property and there could be property that's remaining, and the estate could then be paying some storage costs related to that. That does happen, especially when you're talking about like a single family rental versus maybe an apartment complex. But yeah, not a huge operational change for people due to death.
Yeah, and we've noticed that, when something like this unfortunately happens, we address that in the moment and handle it based on the situation. And so any landlord listening right now, this is something that we'd obviously talk to you about. We'd follow the law. We'd give advice from our law firm on the best way to handle it and follow, the procedures so that we handle it professionally and correctly. But it does seem to vary based on, whether one person and there's multiple tenants on the lease versus someone living in a property alone. So the situation can vary, and so we handle it case by case. Yes? Okay, next.
Yep. The boot bill, as we like to call this one. So the big target here was the booting companies, right? And I don't know if those of you might remember, there was a towing bill not too long ago, and that towing bill went into effect. That effectively closed down some towing operators as far as their ability to do business the way that they were doing business. So there's some changes here. Again, this is one of those things just to be aware of, that look, there's a process that you have to go through if you're going to be booting a property. Really, this is probably going to come into play more likely in dealing with a property where there's an HOA involved, or a multifamily property that is using booting as an alternative method of parking enforcement. And so making sure that there's proper notice that's given before the boot, and documentation to support the boot is a big deal. And it's interesting because there's a lot of smaller operators in the booting world, so only if you're really using booting as a practice to enforce your parking policies is this going to have a change, and a lot of that's really targeted towards the booting operators.
Okay, great.
All right, pet ownership and housing. This one, I think the thing here is that we're really talking about dealing with affordable housing. So it's not just housing in general, right? So there's, it's really something to just be aware of, that there's this additional protection that goes into place for people that are on affordable housing developments. And Jen, you and I were talking about this beforehand. I'm pretty sure that this is not something that's affecting your portfolio of clients, but we want to make sure that people are aware of this, because one of the issues that pops up is sometimes a little bit of information goes a long way, right? Some people will say, well, I heard this thing about you got to let pets into housing. Well, that's kind of true, but it's not the full story, right? You got to get the context for where these things come into play. So basically, this is trying to make sure that there's the same protections for allowing pets for people in affordable housing to have pets. The reality is there's a lot of protections for people to have animals in housing. You can't even really have a completely pet-free community because of all the things that might happen, as far as somebody might have a companion animal, emotional support animal, they might have a service animal. But this is just an additional protection for those people in those affordable units.
Great.
Okay, residential screening. So portable tenant screening reports. That is, whenever I talk about portable tenant screening reports, I like to call it the mythical portable tenant screening report. Now, that's not really true. There are these screening reports that exist. What might they be? You might say, well, it's the idea that somebody could go out and they could get a report, and this report would have all this information that they could say, hey, landlord, you need to use this information for a screening basis. And I say mythical because its use hasn't been widespread. But there's been a change to dealing with the portable tenant screening, and that is, instead of having this requirement that the tenant provide you with a way to verify that it's coming from a third party, you can have to take the paper that the tenant actually has, and if that's given to you, and use that. Why would that be the case? Because wouldn't it be easier to have a third party that you could verify that's doing it as opposed to some paper that might be, I don't know, generated by some sort of online tool? Um, I'm not really quite sure on the why. I can't really defend why this was done as far as a change. The reality is the impact of this is probably not huge because your property management company can still do a screening report. I think the one area to make sure that people are aware of is that, if you're doing a screening report, you have to make sure that you follow the appropriate screening process for the appropriate tenant. So if somebody has a voucher, for example, you can't run their credit report, right?
Right.
But if somebody's a conventional renter and they don't have a voucher, you can run their credit report. So it's kind of understanding and making sure that you're aware of those differences. And if you're not aware of those differences, well, that's okay because your property manager is aware of those differences, right? And I think,
Right.
One of the things, and it's kind of a little bit of a theme when talking about these issues or talking about the new laws, is that I think it would be so difficult to manage your own property to keep up with all this stuff. I think it's just it's employment insurance for the property management industry as a whole. So, and I think it really drives home the need for having a professional property management company to help you out. So, we didn't script that beforehand, so just in case anybody's wondering, but I think it's a really important thing.
Well, and Peter, what you say is true. We've, as a company, we care and pay very much attention to the compliance side of what we do, and fair housing and vetting is one of the most important pieces of our job. And so we are paying close attention to that and aware of the way that we vet and the importance of doing correctly. So yeah, thanks for bringing that up.
Yep, no problem. Well, and that ties right into this next slide too. This is a good order of operations here. So, the Anti-Discrimination Act, right? The Colorado Anti-Discrimination Act, a bit of a change here, basically making it easier for somebody to get a penalty against the landlord without having to prove that there were damages. So here's the thing, the paying attention to fair housing, and making sure that you're not discriminating, that you're doing all the right things. Has always been important. Well, it's even more important now because you've got this additional risk that somebody could say, hey, look, you discriminated against me for whatever reason. They don't have to say, hey, here's my damage. They can just say, give me my $5,000 basically, right? So that's a big deal. We see quite a few complaints that allege discrimination. They can get filed with the state. You can file those as a tenant at zero cost, right? And so there's no cost to make a complaint, yet you could have a potential benefit of a $5,000 penalty if you were found to have violated a can't talk. A law that is anti-discrimination, right? If you were discriminating against somebody, that could be a problem. So it's a big deal, and you don't want to go down that road, right? And I think the thing is that even if you're faced with an allegation and there are no damages, there's still risk and there's still a cost that could be associated with that. So again, you got to be careful and you got to make sure you're doing things the right way. And yeah.
So in this one in particular, there's note about it being like if they're asking for some sort of accommodation, like I need a grab bar in the shower, right? Those sort of things, reasonable accommodation. So that's part of this, right? Is like that we're being reasonable in requests and not discriminating based on that, or is this more overarching than just that?
Yeah, I mean, it's kind of more overarching than just that. I mean, I think you certainly, when somebody's making a modification request for grab bars, for example, the worst thing that somebody could do would be to ignore that request or just say no without analyzing that request and not having a dialogue with the tenant about that issue. So, I think it's important to have this awareness of, hey, what are these issues? What can somebody raise as far as an accommodation issue? Or how do they bring that forward? so that you don't inadvertently create a situation where you're creating some, liability, and you're also wanting to make sure that you're meeting the needs for those tenants, because somebody's asking for an accommodation of some sort or a modification. An accommodation is an exception to a rule or practice that helps them deal with whatever their disability might be. And so you want to make sure that you're doing that where it's appropriate, right?
Right.
So
Yeah, I mean, for example, we're not putting elevators in properties that are 2 stories, but we might need to put a ramp at a front door so they could get in the front door. But we're not required to adjust the size of every door inside the property or door frame to accommodate, right? So where's the line of reasonable?
Yeah, well, there's a lot, and you speak about the ramp, and you say you're talking about a 2-story building, and somebody's like, well, I want a ramp to my unit. Well, their unit's on the second floor. Are they talking about a ramp from the outside to the inside, that's going up to the second floor, or are they talking about a ramp to the entrance of the main building, right? So
Yeah.
there's a very big difference between the reasonableness of those two requests. And so making sure that there is an engagement of dialogue related to those things is super important. And that's a whole big topic on its own, right?
Right.
But it's I think not identifying that those are an issue could be a trap for somebody to fall into this, hey, well, you could be paying out some additional damages here in addition to other consequences. So
Okay, that's great. Thank you.
yeah. All right. So, protections for tenants with subsidies. Here's one of the things that's interesting about this is that if you have a tenant that's on a subsidy and say you've got a warranty of habitability issue, say there was a fire at the building, and you had to refund them part of the rent, half of the rent for the month. Well, if the tenant had a subsidy, that money's not going back to the subsidy provider. It's actually going back to the tenant now under this law, right? So that's kind of a bit of a change. There's also protections related to kind of the source of income. So if tenants are making they're trying to get some rental assistance, you've got to cooperate as the landlord with that rental assistance process. Otherwise, you could be setting yourself up for a claim related to discrimination. You don't want to do that, right? Because you can see the previous slide. So they're all kind of connected here. So if you're not working with that rental assistance, and that's a big change, actually. I'd say for the most part, a lot of landlords were working with rental assistance when it came up, especially, 2020, right? COVID, a lot of rental assistance, a lot of money that was flowing that benefited both tenants and it benefited landlords too, right? Because they were able to continue to get paid. However, during that time period, there was also times where people would say, hey, you know what? I don't want to work with this rental assistance for whatever reason. Well, we're now at a point in time where you can't refuse that rental assistance because you don't want to, again, fall into this area of a source of income discrimination potentially.
Right. And the source of income, was that 23 or 2024?
I want to say it was 23, I think. I don't know. Yeah. I got to tell you though, Jen, the years blur together a little bit for me. So
I know.
It's just it flies by. We say 2020, it was like, wow, that was 5 years ago. How did that happen?
Well, I know that we've made that adjustment on source of income over the past few years, and so very comfortable with that. And we work quite a bit with subsidy, and work really hard to accommodate that, and work with the tenants and with the organizations and all that. So very comfortable there. Yeah. Okay.
All right. SB 2520. So this bill got a lot of attention. Basically, it gives not only the Attorney General's office, but it gives other levels of government oversight and authority to get involved at a property, and potentially even putting a receivership in place for a property if a property is getting to a level of disrepair, right? And so certainly, again, I would say the news helped drive some of the motivations for this legislature to kind of roll out laws related to this. Now, here's the thing. Hopefully, this is not an issue for most of your owners, because you're going to be maintaining the property, right? So you're not going to have
Right.
a property that's falling in disrepair. But it's important to have an awareness of what these things are, right? A receivership is probably most commonly coming up with property comes into play when somebody's not paying their mortgage, right? And you think of a multifamily property where maybe there's some tenants where rent's being paid, but the mortgage isn't being paid. Well, the bank might put a receiver in place. This is a similar mechanism where a government could put a receiver in place to take care of whatever the issue was that wasn't being addressed by the property owner, and then operate the property. So it's a big deal. I think it could be another risk area that people need to be aware of, but not one that's going to be hopefully popping out for somebody who is able to properly maintain their rental property.
Okay, great.
All right, now this bill is a big bill as far as the impact that this has on landlords, the impact that it has on tenants. Talking about dealing with some of the protections for survivors of domestic violence. There's a bigger definition of domestic violence, and it includes stalking, and it includes abuse. And one of the big changes here is it allows somebody to self-attest, where somebody could say, hey, look, this is happening, and it's having an impact on their ability to pay their rent. So what that can do is that can trigger certain protections for the tenant that can give them some rights to a repayment plan, and that can be raised at any point in time during the eviction process. So that can be before demand's been served, it can be after, it can be while a case has been filed, it can even be raised after the tenant is out of the property. So it is a really big deal. It's a big protection. There already had been protections that were in place for victims. This is just a large expansion of that. And this bill is really giving protections for somebody to stay in place, right? So a lot of the prior protections were designed for situations where somebody was moving from the property, where they were moving on and trying to change locations and the protections there. So it's just providing a different form of protection for those tenants that are impacted by some very difficult situations. The other thing is that it also makes it very clear that it's okay for the landlord to change the locks. So if you have the roommate situation where you've got one roommate's the perpetrator, one roommate's the victim, the victim can say, hey, this is what happened, the locks can be changed. And that's important because there's liability for landlords if you're changing the locks on somebody and you're not supposed to be, right? So this at least provides that protection and sort of clarification for the landlord that they're able to do that in this situation. And so these, like it talks about as far as the action items, this is something to more be aware of, and it's something that our clients work with us when they deal with these situations, and unfortunately we see quite a few of these issues that pop up.
Okay.
So in addition to staying at the property, people can also terminate. So their way out is basically getting out with only paying the equivalent of 1 month's worth of rent to sort of break the lease. And then certainly the repayment plan option is definitely available to people. And that the repayment plan is interesting. It's one of these areas where the tenant has the ultimate say on this. So you can propose a payment plan that says X, Y, and Z, but the tenant doesn't have to agree to it. They can say, hey, this is what I'm going to agree to. And there's some statutory limits on what that can be in the time period. It can be a very long time period. It can be up to 9 months. And so that's a lot of things to deal with as far as managing dealing with that arrears. So it's a big bill. It has a big change from an operational standpoint if you are faced with dealing with a situation where a tenant is claiming that they're a victim in one of these areas.
Yeah, and I'm sure we will work closely with you in these situations because we're going to be learning along the way too.
Yeah.
Just making sure we're handling this well. Okay.
Security deposits. Oh boy, these are a big issue, right? I mean, it's a lot of changes related to security deposits. And I guess before we talk about the changes that did happen, I got to tell you about the changes that didn't happen. Because when this bill was first proposed, it was very extreme, to the point of it was going to allow tenants to move in by making payments on security deposits.
Right.
And so, a lot of that stuff got amended out, and so it's narrowed down, but it still has some big changes, as far as what you can offset the security deposit for, and also, how you can, sort of charge back that. And that's a big shift. And there's some things related to how the mechanics of dealing with accounting for the security deposit get handled at the end of the lease, right? So that's kind of a big change. So you don't really have this situation where you can have these contracted for damages. It's all very situational, right? So it all depends on what's the condition of the property. What does that put a premium on? That puts a premium on documentation.
Right.
Both the condition of the property before and the condition of the property after. Those two things are just some really big, important mechanisms to be able to handle these security deposit issues as they come up.
Yeah. This is another screen related to that. I think we have like 3 slides on this particular topic.
Yeah, it's a big one. So I mean, it's one thing is that was kind of, I'd say, more tenant and landlord friendly is bringing the security deposit age into to the current century, right? I mean, it was always about checks, and I think. Well, I know a few people in our office that had to write a check, and they're like, "How do I fill this out?" It's like, oh boy, that
Yeah.
makes me feel old. But there's a way for tenants to opt in to an electronic refund, which can be great. I mean, I think that's great for the landlord. You don't have to worry about like, hey, the check's in the mail. Did the check get
Right.
there? And it's great for the tenant because they can get their money faster and everything like that. And Jen, we were talking beforehand. You guys have a way to be able to handle this, right? For your
Yeah, our
tenant.
software AppFolio has an opt-in option
Great.
that with this new law we can now engage in. So we're really excited about it, because the other thing we do is we need to send it out in a certain amount of time, and we send it um, guaranteed, right, through the mail, and there's a cost associated with that. So I'm hoping that this also reduces some cost.
Yeah, that could be great. And your landlord's having to provide documentation, supporting documentation when they're providing these dispositions. So when you think about it, it's taking pictures. You can have a bunch of pictures, and that could be
Right.
like a bunch of files. But if you had to print all those out and mail them, oh my goodness, that could be
Yeah.
a lot of. We don't need to kill all the trees, right? So
Yeah, and that is something we do, is we send the letter, or we send everything in an envelope. And so this change is going to be good
yeah.
for everyone. Yeah.
Oh, cleaning. This one, it's a dirty business, right? I mean, it's basically normal wear and tear. If something's dirty, that by itself is not enough to say that it's damage beyond normal wear and tear, right? It's got to be really bad in order to be able to charge for cleaning. And so what that means is that the expectation that the property is going to be in a great condition to be able to turn around and get tenant number 2 in the property, that's probably not likely to happen. I mean, I'm sure it does happen where the cleaning is fantastic and that's being done appropriately, but the property might be a little bit dirty when the tenant leaves, and that might not be something that you can charge the tenant for. I think that's a big shift. I think also when you're talking about carpet, you're now on this 10-year depreciation schedule for carpet. So if the carpet's real old, vintage, right, over 10 years, then that's not going to be something that you're going to be able to charge them back anything for. But you could prorate the charges on the carpet if it's less than 10 years, and you're going to have to replace carpet in maybe room 1, right? But if you're replacing carpet in room 1 but not the whole house, you're only charging for where you're replacing the carpet. Kind of the same thing for paint. There's not a time schedule, but again, your painting charges have to be related to where the damage to the property is related.
So again, it's document, 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 and like the concern we have, right, is that a tenant moves out, everybody has a different idea what cleaning looks like, right? And what clean is, and some of our tenants will hire a cleaner and some won't. And so it's preparing for you with your property manager for every transition, how is this going to get handled? But we want to make sure that the next people moving in are moving into a clean property, because that's the biggest concern I have, is just that the experience for tenants continues to be good. And so this will be something that your property manager and asset managers will be working with you directly on, what needs to be done at each transition. To just, to both, do we want to do additional, are we going to set cleaning up so that you can count on that there will be a baseline cleaning, and then pictures taken so that anything that exceeds normal wear and tear will be charged back to the tenant, and educating the tenants on the front end of their responsibility to give us a clean property. So I don't know if you want to speak to that, or any recommendations that you have around that, or if it's just new enough that the idea is that tenants will not be responsible for it if it's basic wear and tear clean. It'll be something landlords need to pay for at transition.
It really is that former, or excuse me, the latter. It's not something that, the degrees of clean, right?
Right.
It's going to have to be pretty severe dirtiness in order for that to be a charge that you're going to be able to pass along to the tenant. So creating that expectation that there's a ownership level clean that you're going to need to do prior to getting a new tenant in, I think that's the right way to look at it.
Okay. So that'll be a change for those of you who are on. That's going to be an adjustment moving into 2026, and your property managers will work with you through that transition, and put a plan together, because we still, that sort of transition clean is a really important aspect to managing your property over time too, and keeping it clean, right? And keeping it in good repair so that it transitions to the next tenant in a really good way, so they then take care of it. So we'll be working hard on this particular issue to do the best that we can to have it be predictable, have the tenants take as much ownership as possible, and making sure that when they leave it is clean, and then doing an amazing job documenting so that if it ever exceeds normal wear and tear, that we make sure that the tenant's held responsible for that. Okay. And this is, I think, the final one, right?
Yeah, that's it's pretty good. I mean, it seemed like a daunting task, right? We're talking about 11 bills in in such a short period of time, but we're almost through it. So 1090, really, this is a protection against deceptive pricing. Where did this come from? I would say it came from this national push related to banning junk fees, right? That's kind of the purpose behind this law and where this was coming from, and it's really all about transparency and making sure that things are clearly disclosed to tenants before they're being passed along. And there's some limitations about things that you can't charge. So you can't charge costs that are related to providing a habitable home. You cannot charge arguably RUBS or flat rate utilities costs. There's an interpretation issue related to this law about how utilities can be passed along. It's very clear that utilities related to common areas cannot be charged. There is some dispute over the issue of utilities to an individual unit and how those can be assessed, but the concern is all about this language that says you can only charge related to kind of the actual use or the use that the tenant is billed for at that particular unit. So when you're talking about RUBS or a flat rate, that's an estimate or a mathematical calculation for what that consumption might be based on some sort of formula. And that's created some interpretation. Sorry about that. Some interpretation challenges for people. But essentially, beginning January 1, charging RUBS presents a significant litigation risk for people. And I think the issue there is, you've got that litigation risk. What's going to happen from that point moving forward? There's actually some hope that there's going to be a legislative fix to clarify that, RUBS was not the intended target of this bill. And, we're expecting a proposed bill in January to address that, which would be great if that does take place. The problem is that there's uncertainty up until the point that that does happen, right?
Right.
And there's some risk. So our recommendation is don't charge RUBS beginning January 1.
Okay. So can you go to the next slide, and then I want to see. Yeah, so this is still inside the utilities. So, many of you have single family homes. Let's say you're in the city of Boulder, your tenant pays directly to city of Boulder and pays that utility, and they pay their Excel bill, and you're good because they're paying for exactly what they're using. Some of you have you might pay the water bill with the city of Boulder, for example, and then maybe we've set up a flat fee that the tenant pays, so it's just an average. That has to change. So now instead you're going to be sending us the bill so that we can put that on the tenant's ledger so that they pay for exact usage. For those of you that have a duplex or a triplex where you have one bill that comes on in and you split it 3 ways, that's where we'll be making some changes where we can either put on a metering system into each unit to manage exactly what their usage is, or we can come up with something. It might just be removed. We may wait a couple months until there's a change in RUBS and we may be able to divide it again. So you'll be having conversations with your property managers who are probably already having conversations with you about this. The other big part here, and I think Peter, you could go into it some more too, but it's also my understanding that community usage. So for example, if you're in we have a property that's got building A, building B, and then there's this is for water usage, and then there's the water for the community, right? It's for the grass and the bushes and the trees. You can no longer charge for that community usage. So people in building A will only pay for the water that building A uses, people in B for what B uses, but nobody will be responsible for the community water usage anymore. Is that correct?
Well, yeah, I mean, no tenant's going to be responsible as a separate line item.
Yes.
Unfortunately, this bill didn't do anything to alleviate that financial burden on your property owners. But that's it's. I think the other thing to keep in mind with this is that it really eliminates what you can charge as a separate itemization. It doesn't eliminate what you can charge for rent, right? And so it's when you're trying to itemize these separate issues individually, that's where the prohibition comes from. So, it's a big change. It's a big change. It's a big change that goes beyond one slide, right? So the advertising piece, you got to be very clear with the advertising, right? So you've got to make sure that there's no surprise fees, that you're advertising at one rate of hey, $1,000, and then somebody goes to pay and they're like, well, it's actually $1,300. Wait a minute, you said it was $1,000, right? You can't have that divide. There's got to be some consistency there, and making sure that you're providing that total amount. Now, there's some things that could be variable. So you've got a lot of single family homes, right? Their utilities the tenants are going to be responsible for. There's no issue with any sort of RUB situation. So, your utilities could be identified as variable cost, right? But it's something that's the tenant's responsibility. That's okay.
Okay.
And so this is kind of a sample of the Schumer box style of disclosure, and not an actual one, but just an example of what something like this might look like, where there's a kind of a breakdown of what the fee is, where it comes from, and any notes associated with what that might be, right? So just kind of a way to give an example of what that might look like. It's all about the disclosure piece, right? And the idea of being transparent and clear and conspicuous. The Schumer box is something that people are probably familiar with seeing, like in a credit card statement, right? It's
right. Okay.
And Schumer, that might sound familiar to some people because that's from Chuck Schumer, who was one of the sponsors of the original legislation related to that type of disclosure.
Okay, so this is clarity, and it's my understanding it'll be this clear in the leases as well. And so it's our intention to make this very clear for tenants and follow this level of disclosure so that there's no confusion on what they'll be paying for. Okay, great. So we are at question and answer time, and this is our first time to go live on YouTube. And I think that I'm wondering if people are able to get on and ask questions, or able to unmute and ask questions, if that's a capability. If it's not a capability, then what I think I would like people to try or to do is to send questions to, let's see, Mel, should we have them just send them to you? Send to Mel, M-E-L, at foxpropertymgmt.com. And you can send a few questions. We'll sit here and chat for a couple minutes and see if any questions come across. You know, our hope for today was sort of to get all this information out to you. Our plan is to send you this deck and send you supporting documents. You can go online and do a lot of research. There's pages and pages and articles and all sorts of things you can read. I think the main thing that we wanted to get across for you today is to give you the education that you needed, and the information you might need so that you can ask these questions, but also so that you're not as surprised when things come up in 2026. So I think that, you know, my hope is that you got something out of this and it's informing you, and that it might be generating some questions that relate specifically to the type of property that you have. If it's a condo and you've got an HOA, it's going to be one thing. If you're single family home, that a lot of these issues may not pertain to you. I think the biggest ones that will affect everybody will be the security deposit and those changes to wear and tear and cleaning in particular. So I think that will be a big change that will be new for all landlords in 2026. So the chat is actually live. So it looks like you can go into the chat and you can ask questions, and we'll be happy to try to get some of those answered. So do you see any of those in there, Mel? Yeah.
It says assistance, could that become an issue for any of us? Like my current tenants are not poor, but they become people get assistance.
Okay, so I think what the question is that we may have tenants in place right now who may be qualified and moved into a place. Can they qualify for assistance mid-lease? Is this something that may happen mid-lease?
So certainly that actually is one form of assistance that we see quite a bit and we see that in the eviction process, where people will get assistance from various organizations mid-lease. And a lot of times those assistance requests might come with some requirements. They get a copy of a current ledger, for example. They get some other information about the landlord and about the lease, so that the organization that's providing the assistance is verifying that, hey, what the tenant's saying is true. And so yeah, that actually happens quite a bit as far as the rental assistance kicking in mid-lease. Now there's sort of the different, there's a different situation if somebody has a voucher, right? And certainly that's a form of assistance, and there's a whole different set of protections that are in place for that tenant that has the voucher, right? Like the screening that we talked about earlier. But you could certainly have somebody that moved into a property, they were conventional tenant, and then they're getting assistance midway through the lease because their circumstances have changed.
Right.
That's a fairly common thing.
Yeah, and this same person chimed in and said, it says, are assistant programs available for any tenants? And would you say yes, but people have to qualify? It's quite rigorous, isn't it?
It can be. I think we've definitely seen kind of a wave of, where there weren't as many requirements to now they're definitely more stringent. And I think there's generally less money floating around for assistance programs than there was 5 years ago. This is just off the top of my head, but and so I think with that, there might be certain things that they would have to qualify for in order for them to be eligible for that assistance. But in general, I think it's fair to say that anybody in a financial, straits might be able to get assistance. The limitation for some programs, though, is if you've gotten assistance previously, maybe they're not going to be able to get it again a second time, right? And that's a big change, because it used to be that, there were people that were basically that's what they were doing. They were paying their rent with assistance. So that's not something that is as common these days as it used to be.
Okay. Another question that just came up is someone asked if you would explain the tenant screening law again. They didn't
Sure.
quite understand it. Could you just jump into that one more time?
Yeah. So the portable tenant screening report is basically that's a service that somebody could get. They could go out and they could hire company A to screen the tenant, so that they could then take that screening report and go to landlord B, C, and D. And instead of paying a fee to landlord B, C, and D, they would pay their one fee to the screening company,
Right.
and they'd have to give that, so that people would have to use that. That's generally what that is. And then the law change was one that made it so that the tenant can now provide you with a physical copy of that portable tenant screening report, where before they just had to provide you with an access code so that you could go and verify that from that company where they hired that to get that information. I think the other thing to keep in mind with that is that just because somebody has a portable tenant screening report doesn't mean that you have to rely on that. You're still able to run your own screening with their permission. You just can't charge the tenant for that screening. So that's where the catch comes in.
Okay, interesting. Yeah. Okay, great. I hope that answers your question. Go ahead and jump back in the chat if you need more information, or send us a direct email and we can try to get you additional information. So we have a question from someone. They said, many years back, when I first put my property on the rental market, I had to professionally clean the property and the carpet separately and provide both receipts to Fox. So they prepared their property for their first tenant. In turn,
Great.
tenants who moved out did the same at the end of their lease. And that's what we've been doing for many years, right? Is you
Yep.
basically get a clean property and you return it in a clean condition. So in turn, tenants moved out who did the same at the end of their lease. If they didn't, that cleaning fee would be deducted from their security deposit. And so the question is this now no longer permitted?
And the short answer is, yeah, it's really not. You're only able to charge for that cleaning if it's, this damage that's beyond normal wear and tear. The carpet damage, it's, the cost of replacement of the carpet is going to depend on the age of the carpet and your ability to replace that. And really, I think that goes with the cleaning as well. It could be a situation where, if you get a soiled carpet, think there's some pet damage and that type of thing, where maybe that's something that if you ended up having to do a cleaning, that you might be able to pass that charge along.
Right.
But in general, that old model is a little bit different. And I
Yeah.
think that's one of the big changes there as a result of that security deposit law change, is that, it's sort of that new cost of dealing with the property and sort of the cost associated with the turn, right?
Yeah.
It's always ideal to have that long-term tenant that's in the property for a long time, and you're not incurring, those costs at the turn. Now there's going to be less of those costs at the turn that you're going to be able to recapture from the tenant.
Right. So yeah, when you have good tenants and they renew, you don't have the transition maintenance cost and you don't have the transition cleaning cost. Yep. Moving forward. I was also thinking that, a lot of our owners who have a lot of carpet in their properties might want to think about the possibility of replacing that with a hard surface flooring over time to reduce that future cleaning requirement. Yeah. So it might be a good capital expenditure in 2026 to replace carpet, or replace it as your property transitions and get to hard surface, so that's not, because carpet cleaning's charged at about 35 cents a square foot, maybe even more than that, carpet cleaning, and it can really add up. And if owners are going to have to be making that, in some cases doing that cleaning, that's going to add up over time. So that'll be interesting. Yep. All right, yep. Let's see. So someone asked about the cleaning after tenant move out is now responsibility of the owner, and that is true unless it's an exceptional circumstance. So if we come into a property and the stove or the refrigerator is a mess, right? Appliances weren't cleaned, that's above and beyond normal wear and tear. Is that true, or is it just about taking pictures and
I mean, it depends. I mean, is the typical lawyer answer, right? I mean, unfortunately, but it really is going to depend on the the exact circumstances, right? Like, how bad is it? You know,
Right.
is somebody else going to look at it and say like, whoa, hey, that's terrible? You know, somebody who's outside of the industry, right?
Right.
You know, if you're gonna show it to a judge, you know, I think there's a difference between, you know, a dirty oven and then an oven that had a turkey left in it when the tenant moved out 2 weeks ago, right? You know,
Right. So
that's a
again, it's document, and if we have questions, we'll be working with you through that. And because this is going to be new to all of us, right?
Yeah.
And so it's going to be trying to do the best that we can for the client, for the property, you know, for our homeowners. So we have another question. For a condo in a large building that has an HOA, does this mean my tenants can't be asked to pay community costs such as trash and recycling in particular, that aren't based on their specific usage? So they're not asking about water. So water might be one thing, trash and recycling something different, right?
Yeah, so I think it's if the trash and recycling charge is associated with the common area of the property, that's not something that you're going to be able to pass along.
So if
right?
it's a big dumpster, you can't pass it along. But if
Right.
each individual unit has their own trash and recycling, then you
different.
could?
Yep.
Okay, so that's interesting. So that that would probably answer their question there. And I think with water in an HOA, a condo in HOA, if the water is not individually metered, that's another thing that cannot be charged flat fee to the tenant.
Right. If you're getting that could certainly be an issue. It again, there's a little bit of it depends on how these things are being assessed through the association and
Yeah.
being passed along. So you know, just keep in mind that you know, there could be some factual variations in these scenarios. But yeah, I think the key thing is that you're not responsible for the common area, you know, water, right? You're not responsible for the common area trash. You're responsible for the charges associated with your unit, and so long as they can be tied directly to your unit.
Yeah. And I'm guessing HOAs are going to be really reckoning with this whole situation too, right? And the way they charge. I mean, there's just going to be a lot of uncertainty.
Yeah, maybe not, because it's you know, it's a different situation for the HOA than it is for a tenant in the HOA. So
Okay.
I think that's where that variation will come into play.
Okay, great. Do we have another question? No. Oh, that's great. Okay, so this has been so great, Peter. Thank you so much for being on this call with us. It looks like we spent, you know, about 50 minutes going through everything, answering some questions, and it was very, very helpful. So thank you for that, and thank you for, you know, collaborating with us on a weekly basis as we navigate all of the changes and all of the things that we deal with on a daily basis in property management.
Awesome, Jen. Thank you for having me, and have a good end of your year.
You know what? We just had one more question come through. Are you up for it?
Sure, hit me.
Okay. So this is from one of our property owners. It says, I do not allow pets in my unit, but a person has an ESA that I have to allow. Clearly, the pet will make the carpet more dirty. Do they have to clean the carpet at their expense when they move out? So if they have an ESA and it, you know, yeah. What's the answer?
I think it really depends. I think the fact that there is a pet doesn't necessarily mean that that's going to mandate that they're going to have to clean the carpet. It's going to depend on, is that damage with the pet beyond what would be considered normal wear and tear, and that's a tough one. It's going to be a tough call to say. So I don't think that you can necessarily count on that they're going to be required to clean that. It's just, is the pet damage beyond normal wear and tear? Is there some soiling of the carpet that is, you know, beyond what should be?
So again, the documentation of that, and also the potentially that conversation of removing carpet whenever we can from properties to avoid that potential cleaning requirement. Okay. Are we?
Now we've got.
Oh, this is so great, Pete. If you got a couple more minutes.
Sure.
We'll go till 3:00. We can answer a couple more. Okay. Okay, let's say, are there any changes in laws about how much rent can be increased at the end of each lease term? So Are there
Not yet.
any?
Don't give the legislators any ideas, right? There's no limitation there yet, right? So you could see where, some of this stuff might be going, right? When you're talking about, well, you can't have these separate fees, you can't have these separate fees, so, rent's going to go up. Then people are going to say, hey, rent just went up. Yeah, so there's no limitation. There's no rent control in place as of this point. So
There is one thing that would be great for you to talk about, though. It is our understanding that rent can only be increased one time in every calendar or in a year. So, for example, if you wanted to increase rent by $100 to cover utility charges, and you wanted to do that in January, that would restrict you then from doing a rent increase at renewal in April,
correct. Yes,
right? So
exactly.
instead, you'd want to wait and do it all at one time.
Yeah, potentially. So you gotta, there's a little bit of that crystal ball, like what's the market going to bear, right? As far as the rental for that, the rental rate for that particular property. But yeah, keep in mind that, a small increase now might cost you a big increase later. So.
Okay. Here's another one. So I think this is a follow-up. This is back to the pet and ESA. Do you mean that if the pet is an ESA, we have to allow the tenant to have a pet? Can you talk a little bit about ESA?
Oh, I'll talk a little bit about it. It is a big topic, but yes, if somebody demonstrates that they are disabled and they have the need for an emotional support animal, you have to allow it, even if the property is a no pet property. So that's the thing. There's really no such thing as a no pet property anymore because of those protections that are there to allow somebody to be able to enjoy the property if they didn't have the disability that they're indicating that they have, right? So it's quite possible that you'd have to allow that pet in that situation, and because the law doesn't treat them as a pet at that point.
Right, right. Okay, thank you.
Yeah.
Okay. Oh, we have one more. Okay, let's see. Is the rent increase, I think the rent increase in 1 year is with the same tenant, right? So if the lease changes hands 3 times in a year, if it's different tenants, it's just that you can't increase on the same tenant multiple times in 1 year.
Yep,
Okay.
yep, absolutely. Good clarification. Yeah, so it's
Okay.
it's the same tenant. So tenant, you got Abby at the unit. If Abby moves out, Ben comes in, could be a different rental rate. Yep.
Right. But when Abby renews in May, and in most cases, all of our leases are a year anyway.
Yep.
So this comes into play in this moment when we are trying to make this adjustment with utilities, where the recommendation is to either don't charge the tenant the flat fee utility or add it to rent. That's where this decision comes in. And I think this is really a personal decision for each landlord based on their property, the situation, whether they want to wait a month or two first, whether they want to wait till renewal, whether it makes sense to go ahead and do that increase now because they didn't plan to increase at renewal. So I think each landlord can have a conversation with their property manager, asset manager to discuss what's best for your property, because you all have different circumstances. And we will be learning along the way. There's very little precedent to any of this, right, Peter? So we're going to see in 2026 how these laws are responded to, right? I mean, and cases will be brought, and then we'll have a better understanding on how things are being handled. And so what we're trying to do on our side as your property management company, and from advice from our attorneys, is to just be really smart and careful about what we do to protect landlords in this situation, so that we are not putting you in a position where you're at risk of a lawsuit or any sort of fine that we can avoid. So we're trying to be very forward thinking and conservative in the way that we're interpreting these laws, along with from your advice, in order to handle this well, so that we don't have any big surprises in 2026. And that's your recommendation, right, Peter?
Yeah, got to be conservative. I mean, I think that's the only way to go. You don't want to be a target for any litigation, really, and there's really minimal benefit to somebody trying to be aggressive when you look at the ultimate cost that could be associated with being on the wrong side of a judgment and something like this. So I think the conservative approach is definitely the way to go, and that's how we're advising our clients.
Okay. Well, we appreciate you. Thanks for taking those extra questions.
Sure.
And thank you all for jumping on and asking questions. And we look forward to continuing to communicate with you about everything that's happening with your property and with changes in the laws. And as we go into 2026, we will continue to provide you information and keep you notified and continue to be a resource to you. So thank you all for your time today. And we'll go ahead and sign off. Thank you.